Hi, Tim Blankenship here with Divorce661.com, specializing in California divorce. We're a divorce paralegal firm that can help you with your divorce anywhere in California. Today we're talking about stipulations and specifically drafting a child support stipulation. Stipulations, briefly, I've talked about a lot, and we've done a lot of these, but there's been some changes recently to what the courts are looking for as far as the language in the stipulation. You can enter into a stipulation at any point in your divorce. It can be before the divorce is finalized, or it can be post-judgment after you've been divorced. You can modify specific orders. But if it's before the divorce is finalized, what you will have is a stipulation or agreement that both of you can sign without going to court, have the judge sign it, and it'll become a temporary order until further order of the court. So now we've touched on what we're talking about. This specifically relates to child support, and they are changing or requiring additional language now on the child support agreement. So when you come to an agreement for child support, here's what they're now asking for. You need to have the total amount of child support that's going to be paid, and from who and to who. So from the respondent to the petitioner. And here's one change. We used to say beginning forthwith, where we could say child support to begin forthwith from X amount of dollars amount from the petitioner to respondent. Forthwith is simply a fancy term that means starting immediately, and the courts are now frowning upon that. At least one particular court in Los Angeles County is saying they want a specific start date. Prior to that, in addition to that, I should say, we also would just simply state the specific amount. So the dollar amount, say it's $1,000, and we didn't have to specify how much for each children. Now we would do that in the judgment. In the final judgment, we have to say how much goes to each child, but we never had to do that in the stipulation. Now we just got a judgment back, not a judgment, but a stipulation back, where they're now asking for us to indicate specifically. So if it is $1,000, it says you must put the children's names and birthdays in your order plus amount of child support per child. So all they're doing is going back to having it be exactly as the language is on the final judgment, on the final child support agreements, where it does have the kids' names and the specific amounts and their date of birth so they know how old they are. We haven't had to do that on stipulations for child support in the past, but now that we've done that, or now that we've gotten this rejection letter back, that's how we learn if there's a change, or if there's a particular court clerk that wants it done a certain way. Just make sure that you have how much is being paid, from when to when, for what child, and how much per child, and you'll be good to go. If you go to our slideshare.net account, we have put up a copy of the child support agreement so you can use it as a guide. I think I had uploaded the previous one, so I'm going to upload another SlideShare, and I'll probably take down the other one where you can get the language specifically as the courts want it, at least in California, which we specialize in getting stipulations approved. Tim Blankenship, Divorce661.com, specializing in California divorce. Appreciate you watching, and feel free to give us a call if you have any questions or would like assistance with your divorce in California. Talk to you soon.